Welcome back today to the Dr. Ginny Show. I am here with Felicia Harris Hoss, and she is our first, mind you, our first lawyer as a guest. So welcome, Felicia.
Well, thank you. Thank you. I'm honored to be here and honored to be your first lawyer guest.
Me too. We will take it easy on you. How's that?
I appreciate that.
So, Felicia, let's start out by telling our audience who joined us today, leaders at all levels of the company, and also executive teams to whom I support and help. Why should they spend the next 20 to 30 minutes listening to us? What are they going to learn?
Well, it's a great question, and I appreciate the chance to be on your show, Ginny. You're such a fabulous host. Today, I hope we have a conversation around what will help your listeners and your executives and your companies think differently about their approach to conflict early in the life cycle of it. I spent the first 20 plus years of my career as a commercial trial lawyer helping companies at all levels and executives at all levels deal with conflict through the courthouse. And about 5 years ago, I pivoted my practice out of the courthouse and into the conference room or boardroom, depending on your perspective.
I don't know why you would do that. I'm kidding, obviously. I went through a very long 4 year and very expensive divorce. And so I am so happy that you're here with us. I have stopped talking about my divorce thanks to therapy. I have overcome the trauma that was associated with it. So I'm very happy that you're here with us because I do believe, based on our previous conversations, that what you're going to share with our audience is going to support them, whether it's on a professional level or a personal level. So I'm really excited about that.
Yeah, away from this conversation, a new way of thinking about conflict and about how they approach it.
So tell us about what got you into this field to begin with and your
Sure.
passion for, I know you're going to talk more about this, for mediation,
Yeah.
for really resolving the conflict before you have to go to a very expensive process through the courts. What was that passion?
Well, it's a long story, but I'm going to keep it short. The short version of the long story is that I love being in the courthouse. I love being in the courtroom. I love the trial aspect of what I did. It is everything it's cracked up to be. But the reality of today is that a lot of parties, most cases get resolved outside of the courthouse. The statistics vary across the field, and there's data from each of the states. But let's just generically say roughly less than 3% of all lawsuits that get filed go to trial. Now, take that piece of information and overlay it with a story, because this is really what is got to me. I tried a case I think it was in 2017. It was a week and a half long federal case, and I represented a couple of senior executives in a private equity backed energy company. And one of them was in his late 20s. And we won the trial. And a year after, to the day, a bouquet of flowers shows up in my office, and my secretary says, "You must read the card because it's not your birthday or your anniversary." And it was from him. And the message was along the lines, "A year ago today, you saved my career. Thank you."
Wow.
And it dawned on me, not that it wasn't known to me, but that was impactful, right? He remembered the day that we got the jury verdict and the weight of that conflict had resolved. And for me, it was just another day at the courthouse, another day at the office.
Yeah.
And so I realized how impactful resolution is, and that no matter what seat we're sitting in, if it's the lawyer seat, the judge's seat, the mediator seat, the arbitrator seat, resolution is the deliverable our clients want. And so in this seat, I'm able to help them reach that more cost effectively and more time efficiently.
Yes. And, I've had my own experiences with lawyers, and I can tell you that while I wanted to resolve things, there's always this almost like an instigation going on about, yeah, but that would make you look weak. And so while you want to resolve the issue, there seems to be a conflict of interest sometimes for the lawyers to resolve the issue, because if I'm being 100% honest, that's how they get paid, right? When they
Right.
litigate, when they go to court, when they make it drag on. In the meantime, our bank accounts keep draining faster than anything else in my entire life before that experience. So what is one misconception people have about the industry and lawyers, et cetera, that you would like to bust?
Well, I want to circle back to what you just said, if I might, because I think it's a really important point, and it's something that a lot of people feel, but they don't say. So I'm glad you said it. And that is this idea that engaging in a conversation with someone who is viewed to be an opponent, an adversary, is a sign of weakness. Because you're absolutely right. That was something that I used to tell my clients. We don't want to agree to go to mediation too early because we don't want to appear as if we don't believe in our case or that you could win or a whole host of things. The reality of it is that slowing down the decision-making process about either going to the courthouse or trying to get out of the courthouse sooner isn't a sign of weakness. It's really a power move, you think about it. What it essentially does is it allows our thinking about the conflict to shift from reacting, filing an answer, or responding to discovery or whatever, to curiosity
Mm,
and trying to understand and make a deliberate decision about what the path that we are either on or could be on to get resolution, the ultimate deliverable on the table. And I could talk more about that, but I think that's really important. And I'm so glad you brought it up because that is something that resonates a lot in our industry.
yeah. What would you say is one of the biggest challenges that you observe in your clients or the people that you engage with during your daily?
Well, in the mediation field, a lot of there's weakness is one issue, and the other issue that we hear all the time is we don't have enough information. So I think information is one of the biggest challenges. Once you have lost the trust, the connection that you had with whoever it is on the other side, and we're talking about relationship disputes. Not talking about the hit and run fender bender thing where your complete strangers are dragged into the courthouse against each other. We're talking about relationships, businesses. Once that trust is gone, that usually, and lawyers advise this, either cuts off or restricts communication in all regards, whether it's written or verbal or whatever. And so, what we do, or what I do in my early mediation practice, is we have a set of guidelines. And as one of the steps in that process, the neutral, me, I help to lower reactive evaluation and ask the parties clear questions about the conflict so they can figure out what is this about? Is it truly a misunderstanding? Or did someone really violate the law? Do we really need to take legal action? And can we resolve it? And then once you know that, you're able to say, what do I know and what do I need to know? And what do I have access to? And this is the information exchange step. It's the second step of this process. And what I'm able to do, what my colleagues who do this practice do, is we help the parties identify the key pieces of information. We're not trying to go persuade a judge or jury, so we don't need 10,000 pages of documents. We just need maybe those 5 or 6 key pieces of information.
Mhm.
We confidentially exchange them because the entire mediation process is confidential. We confidentially exchange them, and then we engage in a risk assessment process, and then we negotiate. And through that 4-step process, we're able to slow down our thinking, ask ourselves the tough questions, and deliberate among ourselves about what is the best course of action for us. Where do we want to be? A lot of times when you get in a lawsuit, you focus on what's in the rearview mirror, right? Everything at the courthouse at trial is already happened.
Right.
It's the rearview mirror perspective. What I try to do in mediation is get an understanding of what's in the rearview mirror, but turn the focus around to look out the windshield. Make it, where do we want to be and where are we going to land? And let's talk about what helps us get to that position so that we can move forward in our career, in our business, in our race to get that product to market before our competitors or whatever the case may be.
So let's do this. Can you recap for us what were the 4 steps that you mentioned?
Sure. So the first step is an assessment of what is the conflict. What are the key issues that we're really upset about? The second step is an information exchange, right? What do you need to know? What do you know? And what do you need to get from the other side to better understand your risks and your opportunities for resolution? And you exchange that. The third is a risk analysis. And what we do in that process is the neutral, me, would talk to both sides confidentially about what we just learned. And with that information, we can overlay if it's a truly illegal issue and where's the venue, who's the judge, all those things or aspects of that. We can then come up with a range of options, dollars if it's a monetary issue, and put those in decision trees. And by putting them in decision trees, we're then able to look at various machinations. If this happens, then how does that affect that? And then the last is the negotiation. Once you have a range of possible options for resolution because you've done your risk analysis, you can negotiate. And I should say that part of the risk analysis in the mediation process actually opens up a window or a door for an outcome that is way better than you could ever get through a courthouse or a judge. And just briefly, I'll tell you why I say that. A judge or an arbitrator can only really decide the facts in the law, and the remedies are winners and losers. That's pretty much it. In a mediation, especially a mediation, if you're dealing with restrictive covenants in an employment agreement or between suppliers and or with customers even, there are oftentimes values, things of interest that are non-monetary that can facilitate a resolution and actually sometimes lower the dollar value of the resolution because it's not just I want money. Perhaps we need to renegotiate that term in our agreement, or perhaps we need to modify this provision in how we address this aspect of the delivery of the product or whatever. There are things you can do in a negotiation, confidential negotiation, by the way, that the courthouse or an arbitrator can never even consider. The message is yes. And let me be clear, not every case is ripe for mediation. Not every, sometimes there are legal issues that need to be redressed at the courthouse. But most cases, remember the statistic I just said, roughly 3% of cases actually go to trial in the country. So most do get resolved, right? So what we have learned is that if you go to mediation, you get to decide if you want to go to the courthouse. You can resolve it or not, but you're in the driver's seat because you can't control the other side. And oftentimes direct communication just invites reactive devaluation and more confirmation bias. They're doing that because that's exactly what I expected them to do. So whatever they offer must be good for them, bad for me. I'm saying no.
Yeah.
Versus coming in and saying, well, is it possible that this could happen? Or have you thought about whether that person who is not in the conflict, what they might say if they were under oath and on the witness stand? How would that affect your analysis and your risk propositions in the conflict itself? So it's really just opening up a broader dialogue and letting your brain start to think instead of react.
And that's the key. You mentioned that before to me earlier about slowing people down because emotions are really high. So you mentioned different scenarios, whether it's something happening at work, like employment law, whether it's something personal, like it was for me with my divorce. In general, what are some of the faux pas that people are making or companies and leaders within organizations, executives may be making? And what would you like them to do instead?
Faux pas in the sense of how they engage or
Just faux pas in terms of things that we're doing that we shouldn't be doing, that we should really think twice about doing that and instead do this. Any of those come to mind?
I'm trying to think of a few. Well, let's just take some of the very common scenarios, and that is how we respond to, slights at the office, for example, right? Sometimes we don't communicate. We just internalize that. And instead of engaging in conversation in which we go to someone and say, you really said something the other day that got me thinking, I'm wondering if I could just ask you about that. We're so used to today, in my view, and I see this in my mediations, to instant gratification. And when I was a baby lawyer, I was involved in a really, really big lawsuit. It was a $120 million case between two big companies over some credits for environmental stuff. Really complicated. And we were in a deposition, and the lawyer for the other side came in one day and said, I want to propose something. I don't remember what it was. But the lawyer who was the lead on the case, extremely bright and taught me tons of stuff, he said in response to that proposition, these 5 words, let me think about it.
Great words.
Let me think about it. And the other lawyer just said, walked out of the room. We went back to the office and we thought about, and we what's good about it, what's bad about it, what can we accept, what do we need to reject, as opposed to just saying no because it came from him, right? And I think that lesson in and of itself, that those 5 words, let me think about it. If executives use those more often, as opposed to trying to meet that expectation, I need to respond fast. No, take a minute. It's okay. Take a minute and think about it. I had a conversation yesterday with some lawyers about a case in which their client and them, they're just reacting. And I told them that story and they were like, we get it. Now we just need to think about it.
Slow down to go faster. So that was one of the faux pas, trying to be on it, to react right away and assume that because the other party suggested it, that it's bad.
Yeah.
And in fact, think about it. Just take a beat and consider. And I would say that is applicable to everything.
Parenting, even if your kids ask you, say, well, let me think about that.
When my son will make a suggestion for something, instead of being like, no, you're not doing that. Like, well, let me think about that.
Yeah.
Or the other way around, where you think that would be a great idea. Well, maybe think about it and think of other things you haven't considered yet. Felicia, let's go back to the question I asked you, and then you went into the weakness, because sometimes people think that when you want to resolve an issue that you may look weak, and you busted that one and you say, well, absolutely not. Is there another misconception that people have about your industry that you would like to bust right now?
I think there is. And it's this, is that most lawyers who are courtroom lawyers, who are trial lawyers, we're just hammers. To every problem, there's a nail and we're just hitting it on the head, right? Let's think about this analogy. Every hammer that I've ever used, around the house, that kind of, there's 2 sides to it. There's one side that applies the pressure and then there's one side that relieves it. And lawyers are that way too. We can apply pressure when necessary, but we can also help relieve pressure. And I think one of the things that is a misconception is that when we go to a lawyer, oftentimes, whether it's an in house counsel or an outside lawyer, we're sort of thinking about what we see on TV. This is what they do. This is what I need them to do for me. Instead of thinking about it before you go and saying, what is best for me? And what kind of questions can I ask this person, this lawyer, and get their feedback on all of my options. So the key, I think, misconception really starts with the prospective client, and the prospective client should be thinking about the key questions, what they want out of the relationship. When I was sitting in that advocate's chair, there were two questions I always find success, and that always opened up an opportunity to talk about all of the options and maybe some things that we had thought about. Do we need to bring in another party? Those kinds of conversations that lawyers like to have. In terms of options, if you are, let's use an employment, because I did quite a bit of employment work when I was in that seat, you are switching jobs. You
Mhm.
don't want to be tied down at the courthouse the next 2 or 3 years.
That's right.
You want to be able to move on with your career, reestablish yourself, and be the best and brightest and boldest person possible. And having to go take a deposition or respond to discovery requests or show up at the courthouse for 2 weeks for a trial really isn't in the game plan.
That's right.
Think about that.
Yes, and we talked earlier about making strategic decisions that are in the best interest of your ideal goal, your ideal outcome, and if you are an executive, in the best interest of the company in many cases.
Yes, yes. I'm a big fan of Sun Tzu, and one of the things that Sun Tzu says is that the superior warrior is the one who wins the battle without the fight. You
Mm,
get to preserve all your resources, all your relationships, and you still win. And so this is part of that slowing down, right? Think and plan. We do it all the time as part of our normal job. We have budgets, which are planning documents. We have goals set out for us throughout the year, which are planning processes. Conflict is no different. Plan it. How do you want to resolve it?
I love that perspective, Felicia. And Felicia, if you're speaking directly to executives, what leadership skills in this sphere of law and conflict resolution and negotiation, what is one critical leadership skill that you believe executives need to develop?
Listening. Yeah. And being curious, asking insightful questions instead of always dictating or feeling like they have to have all the answers. Recognize that we don't have all the answers. And I've seen some executives in depositions who did just horribly. They felt like they had to answer every question because of their title or their ego or whatever. Instead of saying that responsibility fell to somebody else, or I would need to check on that. It's one of those situations where listening really is underrated.
Absolutely. And this is not the first time that we have heard that listening is one of the top leadership skills in many different contexts, such as well being. Like that was my last episode with Amy Pierre Russo, and we talked about listening as a way to understanding your environment and how
Right.
people are doing. So thank you for that answer, Felicia. Where do you see the greatest opportunities for growth in this space?
Great question. In what I'm doing right now, the greatest opportunity for growth is in helping leaders and executives from their perspective appreciate how to use lawyers more effectively
Mm,
and how to use the process for conflict resolution more effectively. And in that way, what we do is we open up the courtrooms for what they're best at, and that is addressing legal problems. And if we can modify our approach and how we use lawyers and really, and a lot of in house teams already know this, and they want this from their outside lawyers. Our outside lawyers are extremely smart, extremely effective. But there's two sides to the coin. And so we all have to essentially work that. This is where the mediator comes in because we're able to come in as a neutral and help both sides facilitate those conversations that would otherwise not occur. And so the greatest opportunity is in that, in helping those conversations that are not happening early happen
yeah,
so that those strategic decisions are made. And let me just say this because I'm certain probably some of your listeners are parts of publicly traded companies and privately backed companies. This kind of thinking and this kind of approach to relationships and conflict resolution is really beneficial in the marketplace because we know that in the era of social media, I mean, literally, I get daily headlines of cases that got filed that day against big companies. And so, if we're able to confidentially resolve some of these disputes, and manage that process and land the plane safely and softly
private.
without the social media stuff, how much better is that for the value of the company and your relationship with your marketplace?
Exactly. Now, this is gold. I really appreciate what you're sharing with everyone, because here's where I see the problem is that this is not something we deal with every day unless you're in that field. Usually as an executive, this is the one off. This is the exception. This is the maybe once every 5 years. I mean, hopefully, right? You're not dealing with this every single day if you're not in the field of the law. So what you're sharing with us, it's insightful and it's informative from my perspective as I'm listening to you. And I think also that you can apply it to your life, not only to business, because we may be in situations, sometimes even with family members, with business partners, etc., where we find ourselves having to counsel with a lawyer, and sometimes we're not guided in the right way. I have my own experiences of being misled by lawyers in the past. So I have this mentality of always informing myself now and being very critical in a good way of the advice that I receive and double, triple checking it. I love
Yeah.
the idea of the mediator as a neutral party that can support to resolve the conflict that obviously it means something to you. Otherwise, you wouldn't take it this far.
Yeah. Well, and I went through a divorce too, and one of the pieces of information that my divorce lawyer gave me that I've shared with parties in mediation, and I will share it with your audience because I do think it is profound, and that is this: conflict happens. And the people around you, the people you work with, the people you live with, your family, they're not going to think any less of you because you're in a conflict because they've been in their own. What they will notice, though, what they will remember long term is how you manage it, how you go through it. And I do think that is something that oftentimes gets lost when that initial brain reaction is, I need to fight versus, hold on, let me think about this more strategically.
Yeah, the reptilian brain kicks in.
Yep.
Emotions flood you, and that's when you have to ground yourself in ways you may have never explored before. Let's just say this: I began meditating during my divorce because I figured, it's either going to be a Xanax or meditation. So
Yeah.
I opted for the meditation piece. No judgment. So thank you for that, Felicia. Let's go into our lightning round. And before we do that, is there anything else you would like to tell our audience as we talk about conflict and resolving conflict and having a sense of where do I want to go? Like, what is the outcome that I want? Is there anything else you want to share with them before we move on to a more lighthearted part of our episode?
The other thing I would share is this, and this is more on a professional level because my elevator speech used to be that I'm a contracts and employment lawyer. And the reason why I said that is because every successful business has both. It has contracts and it has employees. And so I would say this professionally, think about when you are drafting those contracts, especially significant contracts. And most of them nowadays routinely have dispute resolution provisions in them.
They do.
Think about drafting that dispute resolution provision between that counterparty to include reference to the EDR mediation process starts to sour, or if there is a hurdle that can't be cleared easily, doesn't automatically get sent to the courthouse or into arbitration. Give yourself an opportunity to do exactly what we've been talking about. Take a step back and think about it and engage a neutral to help both sides better understand the conflict. And most likely, you're going to resolve it more efficiently and more cost effectively.
And Felicia, you said EDR mediation process. Is that what you called it?
Yeah, EDR, early dispute resolution mediation process.
There we go. Thank you. And I actually have that in my contracts with my partners.
Good.
I have a mediation. That's the first step, mediation, not litigation.
Yeah, a lot of companies do that.
Excellent. Well, let's go into a lightning round. I'm going to ask you three quick questions. Just give us your answer based on what gut answer comes to you. The first one is, Felicia, what would you tell your younger self today?
I think I would tell my younger self today to slow down my thinking a little bit more
Hmm.
and to be more inquisitive about what is driving other people's reactions and other people's conduct and speech. I do that now as an adult, but my younger self, I didn't do it so much. I was an advocate.
Yes, I'm sure there's a lot of people listening to us today that can relate to you because we tend to be very reactive in
Yeah.
society.
Yeah.
So it does take that extra dose of emotional intelligence to just self manage
Oh,
and to say, wait, I am not going to respond in the way that I really want to. I am going to take a beat.
I used to tell my clients that in a way to sort of make this point real
Uh-huh.
is that sometimes people do things to get a reaction. Don't give it to them.
Very wise. Very wise. The second question I have for you in the lightning round is if you had no limitations of time, money, resources, what would you do?
I think that I would still be doing what I'm doing now
Hmm.
and continuing on this path of working with the American Arbitration Association to
Hmm.
promote EDR mediation and so that businesses can take advantage of it. Probably write a book or two on it and make sure that there's something out there that lives beyond me, perhaps, to help
Yes.
lay a foundation for it.
Well, let's make that book come to reality. I know that you are collaborating on many different projects to write different things, and this book is definitely in you. So, as a two-time author working on my third book, I highly, highly recommend it. It is so rewarding to write a book and put it out there for the world to enjoy and benefit from.
Well, I may have to talk to you some more about that.
Of course, I'm always here. And my last question for you, Felicia, is what is the best piece of advice you've ever received?
The best piece of advice is what I said earlier, and that is when we go through conflict, it is a normal everyday process. And to just take a step back and think about how we're responding to it. And I have to tell you that one moment in time when I heard the words, let me think about it,
Yes.
it all makes sense.
It changed everything. Thank you so much, Felicia, for your time today, for your knowledge. Thank you for the work that you do in helping so many organizations and leaders and people resolve conflict in the most productive and self-caring way, quite frankly, because we all know that when we are faced with just conflict between parties, especially parties that have had a relationship, it's gut wrenching. It is heart wrenching. We lose sleep. We lose our productivity, our bandwidth is taken up with the worry and the concern and what will happen and all the things that do happen actually
Yeah.
sometimes. So thank you for having this much more gentler and smart and wise approach to solving conflict and for sharing that with all of us.
Well, thank you for having me. It's been fabulous. I really enjoyed the conversation, Ginny, and I'm thankful to be on your show. And I wish you and your audience the best in conflict resolution.
Thank you so much, Felicia. And for all of you who have listened, if this conversation has sparked anything for you, please share this with people in your network so that they can also gain the benefits of listening to Felicia. And we will see you at the next episode of the Dr. Ginny Show. As usual, live with purpose, lead with joy. We'll see you soon. Bye, everyone.
Bye bye.